You're listening to Forward Faster, bite-sized insights for entrepreneurs.
An IP strategy is how a company figures out how to protect its invention over the lifetime of a company and use that to enable them to effectively compete and build a product that can have some period of time where it can have a superiority claim to its invention over its competitors. They need a strategy because over time, markets change. Companies need to realize that they're looking 20 years in the future when they invest in building a new idea. And they need to understand what the world's going to look like in 20 years. So you want to be able to patent the future. You want to be able to think about the evolution of your product over time so that you're building a patent space that protects any new ideas that could emerge that could make your product obsolete. Some of the biggest threats that are opposing to IP is in the space of software. There have been some reforms in the sort of 2010-2012 period where Congress is looking at changing the way business method patents or software patents are being granted. And software used to be just a copyright. In the 1990s, software became patentable. We're going back to questioning whether software should be patentable. For a software patent to be granted, it has to be a patent where code tells a machine what it's doing. So in this great age of Internet of Things, we see an explosion of new ideas that could be patentable. However, if it becomes virtual, is it a machine or is it a copyright? Or is it, so a digital asset now, there's this sort of tension between, do you copyright it, do you have trademark, or do you have a patent? So that's a big threat in patenting right now. I think in the future, IP challenges are going to evolve. Blockchain is a very interesting idea. We now see blockchain in currency, but imagine now if IP could be in the form of a blockchain or a smart contract. So if ideas or inventions are instantiated in a smart contract and then shared and licensed through a smart contract, do you really need a patent? Now that smart contract becomes a tradable asset where you can directly have a ledger, you can have capital associated with it, it's easier to license, it's easier to share, and it's encrypted and protected. So maybe patents are obsolete in the format that they are being granted today and shared and licensed. Blockchain could easily replace that and has all the mechanisms for licensing, protection, as well as potential damages calculations when you find out that someone's using it illegally. There are several different forms of intellectual property. One is a copyright, one's a trademark, one's a trade secret. A copyright is the form of literature. So copyrights are when you're writing a script or you're writing a book and you want to now license that story to be filmed on television, you have to get the copyrights for that. A trademark is just your brand. So you figure out a logo and you have to get a trademark so that no one reuses your logo. This is something I see in China all the time. We have a company, Sonic Faith IP, we go through the web and we just search for logos. There are copies of Nike in some form. You have the swoosh in it or something, and we have to shut those down. That's a trademark. A trade secret and patents are interesting. Intel, for example, only does trade secrets now because they're the only semiconductor company left that actually manufactures its own chips and they don't outsource those designs. So the manufacturing process for what they're doing is now a trade secret. The problem with patents are when you patent something, you're revealing how it's done, but you're telling the world, I have 17 years of a monopoly on this idea. But you can never patent enough to create an idea, and you're actually giving away the methods. And the only tool for protection right now is litigation or a license settlement. You can imagine that if we digitize this through the blockchain, that would be a tool. But there are software tools for searching for infringement. There's IP analytics tools emerging that have machine learning capability that allow you to relate patents to products. You can find if you're infringing on an idea and then you have to go get a license, or you can search for prior art. There's a ton of patents that search for prior art to make sure your idea is new and no one's infringing on it. And anography is a tool, and we use that tool here at Luminate. And there's another tool that we use, Clear Access IP, that helps us map patents to products. And these software tools help you build the landscape for infringement potential. So the danger of doing a patent is someone could do a design around your patent and make it obsolete. If it's a trade secret, you can have it for life, like Coke. Coke is a trade secret. It's been around for over 100 years. It's very hard for companies to decide what is the best form for infringement. It really depends. If you have a very complex process where being able to detect how something is being implemented, chances are a trade secret is actually a good model, because you really want the whole process all the way from putting the raw materials together, building the product, and then actually distributing the product in some cases. Sometimes a trade secret is better, especially if it's a complex problem and you will have to have a lot of patents to actually protect it. And then also, you can hire people and you can have non-competes, and if they leave and trade that idea away, they have a big problem. So you can protect your ideas through trade secrets, and you have an infinite amount of time essentially to protect it. That's why the Coke formula is so interesting, right? It's a trade secret. Companies that have a single point solution that they want to have a horizontal impact where they're going to license other companies to implement it should have a patent. If you're not controlling the whole process, patents are very valuable because you can license your technology more easily, and you can share and partner with other companies to build and distribute it. If you're a small company and you have limited resources and you're trying to decide whether you should patent or have a trade secret, you really need to think about what you can afford in terms of maintaining a trade secret. It's way more expensive than you might think. First of all, you have to hire people and maintain a staff for a lot longer time. If you in the cost of maintaining a staff who all are going to be in on this trade secret can be incredibly expensive. You have to be able to raise enough money to have the right number of people in your company at that time that's implementing the process and keeping it a secret. If you have patents, you can start with all by yourself. You don't have to have a team. You can have a researcher at a university, you can write the patents, you can file them, you can have them in application format, and you can maintain those for several years without ever having to build the secret. So in many ways, patenting is cheaper than a trade secret, even though it seems like it wouldn't be. So if you built a company, you hadn't done any patenting, and you were already, let's say, at 20 employees, and you already had maybe $1 million in the bank, you do have a trade-off at that point, because now you have the team, and you can make that decision. But if you're starting from scratch, it's better to patent. Some of the biggest mistakes people make in developing an IP strategy is they forget that their products is inside a whole set of other problems that are being solved. So we call this the job map. Essentially, your products are performing a job to get something done. And your product is usually in maybe step 4 of an 8-step job map. And this job map is define, gather resources, set up the resources, implement, execute the job, check, modify, redo the job again, and conclude. And you may be the set up the resources part of the step, or you may be the monitor and modify part of the step, or you may be the execution part. You need to be able to patent across that whole landscape, because lots of jobs become obsolete. And you may be the critical job that becomes obsolete for an execution step that moves forward to do more of the prepare, design, setup piece of the job. Or you may get subsumed by someone who just extends into the monitoring side or modify side and say, hey, I can redo the execution. So you need to understand that landscape. And a lot of companies don't realize they're part of a broader set of jobs that are performing in a value chain, and that they can be disintermediated by those other companies. The biggest advice I would give a company is make sure that the idea that you have is the source of tremendous value in the beginning. If you are a piece of another product, it's better to patent and go license right away, and don't bother raising a lot of money to build a company and build a product. It's better to prove out you have an interesting idea, prototype it, and then quickly go license it to a big company, because companies are starving for innovation right now. And you don't need a lot of money to get to a provable concept. If you have a full product, And then it's important to make sure that early on you build a substantial patent portfolio while you're building out the proof points. And I think if a company took 10% of their product development cost and contribute that to patenting, they would have a much more valuable exit, even if the company fails. Because then you're sitting on 10 or 12 patents and your idea and the prototype, as opposed to one patent and no market and no customers. So it's important to understand that spending the time drafting your claims for that job map and making sure you have at least a prototype is built before you rush into marketing and sales and building a whole company. The metrics that a company can use to determine if their IP strategy is effective is really to look at how fast the USPTO is able to grant you those ideas. So if you're getting fast grants, it's effective because chances are you don't have a lot of prior art. Another key metric will be when you're talking to a very large company and you do an analysis of their IP portfolio, is there a gap? Are you seeing that there isn't a lot of patenting going on in your area, but you see in some areas there's large companies patenting around you? So you can see that you're in a gap. So if you actually are in an area that doesn't have a lot of patent activity, but you're adjacent to markets and technologies that are active, then you know that you might be filling a gap that someone wants. And that's a good metric to know that you're filing in the right places. It's important to not be competing with large companies in the patent space. You really need to make sure you're patenting where they're not. And then you need to make sure that the connection of those patents link to those ideas so that you can possibly license those ideas to those large companies. Assessing the value of your IP early on and the contribution of your portfolio of IP value to your overall company is a very difficult thing to do. But normally, if your idea is replacing something else in the market and you can calculate how many units are being sold and what you think the royalty rate's going to be, you can build a discounted cash flow of your licensing potential. So the way to value patents is to look at your future licensing potential, which means you need to understand what products and services that you're trading up for. In almost any market, there's licensable data. So you look at other patents in that space, you look at how many units are sold, and you say, hey, there's 1% value contribution here. And if my patents were licensed, they would be worth X in the future. Now, you look 5 years in the future and you say, okay, what's the potential that we would win 20% of the market? Well, you could say, well, there's a discount rate of the risk is 40% discount rate. So you just do a discounted cash flow and you can calculate the exact value of that license. Now, the other big piece is how many patents do you have? Well, you need to have many hits on goal. One patent isn't going to be enough because that one could be invalidated. The second one can be invalidated. So you need at least 5 really good patents that are licensable that can do this calculation. And pretty much one of those will hit. So that pretty much is the metric you need. If you only have one patent and you're betting on the future, chances are your patents are worth 0. So you really do need to have a pretty broad look at how the future is evolving, be able to calculate that license. Now, then the question is, what's the contribution? Well, that all comes down to negotiation. So when an investor comes to your company and says they're willing to take that risk, you can tell them the downside risk goes away because I have this patent portfolio. If I didn't have this, there would be nothing to sell. We failed. If I do have this, you can sell the IP. And then you can calculate the ratio between the two. And so that's a long-winded answer to a very complex problem. But essentially, you're looking at future licensing value, discounting that back, and then looking at the overall value that it takes for you to build the company. And then that's how you calculate it.